All right, good morning, everyone. It is now 10 o'clock, and we're going to start the webinar. My name is Alan Carey from Concrete, Ontario, and thank you very much for tuning in this morning for the Fit for Duty webinar. With the upcoming legalization of marijuana in October, employers are faced with many challenges to try to address the new legislation with their employees. We're here today to provide you with an overview of some of these challenges and what can be done to address them. Today's presentation is being used with the permission of Norm Keith, who is a partner at Fasken Martineau, and Norm is available to provide additional support and guidance in regards to this topic from a legal perspective. If anyone would like to have their own Fit for Duty training, please contact Norm directly using the information on the screen. Before we get started, just a few housekeeping items. This will be a 45-minute webinar. We're going to leave about 15 minutes at the end for questions and answers. All participants are muted and will remain that way for the remainder of the webinar. If you do have any questions or comments, please use the Go to Webinar Questions pane on the right side of your screen and type in your questions and comments. This webinar will be recorded, and we're going to post a link on the Concrete Ontario website at the end so everybody can access the full recording. Your presenter today is John Scanlon. John is the safety manager of Pioneer Construction and Fisher Wavy. He's a CRSP and sits on the regional screening committee in North Bay. John has worked in mining, industrial, and construction, and was a guarding specialist for the former IAPA. He's a labor chair of the IHSA Labor Management Committee in Sudbury. He's also the chair of Mid-Ontario chapter of CSSE. He sits on the health and safety committees for ORBA, OSSGA, as well as our committee at Concrete Ontario. And in 2020, John will have 50 years in the safety business. So congratulations, John. Welcome this morning, and I'll let you take over the presentation.
So, good morning, everybody. First of all, thank you for joining in and sitting in on this presentation. Like Alan said, I'm going to be 50 years in the business in 2020, so it's a good thing it's a webinar and not a Skype thing, so that you can't see me. That's an old picture that's up there. So the idea of today is just to give you some information. It is a very, very difficult situation at best to put a process in place for this upcoming the legalization of marijuana. And even so, you know, when you look at medical marijuana, there's a few issues with that as well. But what we're going to look at is issues and legal overview of alcohol and drugs. So it's becoming, really the buzzword is fit for duty. Even though we're looking at the legalization of marijuana, obviously alcohol's been legal for years and years and years, and there's still issues with alcohol. And just as a kind of a sidebar, I got a call the other day from one of our employees that asking if he could bring his marijuana to work with him, and you know, he's a truck driver, and my response to him was, we don't let you bring a 6-pack of Molson in your truck now, so I don't see why it would be any different. So so importance of fitness for duty, the policies, employee reporting for work unfit for duty, unsafe work behaviors, unsafe work conditions. So the unfit for duty occurs in safety sensitive positions, and we all, I mean, Sunwing Airlines pilot was, there was a scenario that presented itself from that, and can have serious deadly consequences. And if you look at the Metron construction accident where those Christmas Eve 2014, those people were killed, again, huge issues around that, and more prevalent than expected. And there were 2 TTC employees caught on the first day of testing. So again, it's there. It's going to just rear its ugly head even more as the process moves on. And as we all know, October becomes legal, so it's going to be huge. So drugs and accidents, disturbing statistics, U.S. and Canadian sources are where this was derived from. So 93% of all businesses are affected by substance abuse in some way, shape, or form, regardless of what that is, whether it's alcohol, whether it's pain pills, you know, prescribed pills. There is a huge issue around substance abuse in the workplace. 70% of estimated 14.8 million U.S. employees use illegal drugs. So again, huge, you know, statistics. Unfortunately, we don't have a Canadian one, but it still plays out that we can kind of comparatively look at that and say we're probably not a whole lot different or far off from that, right? Marijuana is the most commonly used and abused drug by employees. It's then followed by cocaine, and of course prescription drugs are huge. 38 to 50% of compensated claims involve substance abuse. So if you take it back and you sort of go through the process, you find that there was some form of abuse, substance abuse to that compensation issue. Workers having problems with alcohol abuse 2.7 times more likely to have injury-related absences. So, and that's been a statistic for years around sort of the alcohol thing, is people that have the dependency on alcohol have those injury-related absences, and not just that, but they also relate to off-the-job situations where it's huge drain on the system. So legislative background: no comprehensive provincial or federal legislation. Guidance from various areas of the law, privacy, human rights, employment or labor groups have made different presentations, and laws vary by jurisdiction, but generally the right to impose alcohol and drug testing is limited in Canada. We're going to kind of broach on some of those issues a little bit through the presentation. And testing is subject to legal challenge. And I mean, it's pretty well the nature of the beast that we live in is almost anything going to have a legal challenge put to it. So this hasn't made it any different. Depending on legal agreement, alcohol and drug testing can be established. So bilaterally through negotiations with the union, or unilaterally through management rights. So again, there's two avenues to look at this. If you are a unionized environment, you can sit through your negotiations and come up with some type of process that allows you to have alcohol and drug testing established within your workplace. Or again, if you're not unionized and you feel that is going to have to be a situation that you partake of, then unilaterally through your management rights, you can ask testing be done. Unilateral established rules must satisfy the best. So from Lumber and Sawmill Workers Union, there was a challenge, and it's the unilaterally established rules that must satisfy the test. So, and that decision is not posted in this presentation. So labor rights and restrictions: the rule not be consistent with the collective agreement, not be unreasonable, and be clear and unequivocal. And that, just before we went to air, Alan and I were talking, and unequivocal is huge. To me, is the word. It has to be absolutely clear. There can't be the minutest chance that you can open that door. So if you're going to put a policy and a procedure in place and a program rather, then it has to be unequivocally, here it is, it's clear, and everybody understands. And of course, it has to be communicated. The rule must be brought to the attention of employees before the company can act on it. Employees must have notice that a breach could result in discharge. If the rule is used for discharge and consistent, enforced by the company through the time it was introduced. So again, it's like any other policy. We put all sorts of policies in place, and the idea is that those are enforced consistently. So for the same offense, whether it's one employee versus another employee, that you're consistently going to enforce the same process. So a unilateral rule with disciplinary consequences must be proportional under balancing of interests, and that sort of takes to an analysis process. Employer safety interests should outweigh employee privacy interests. Again, if you look at the unions and so on, and that process, sometimes that's a real fine line between that safety interest and how we impact the employee privacy. So, everybody has a right to privacy, but again, everybody has a right to come to work and be in a safe workplace. So it really kind of plays out. This falls under the reasonableness requirement of the KVP test. KVP was another issue where there was testing done, and how the testing is done, and whether it's random testing through that process. So again, it just opens all those doors. Testing must comply with human rights law that prohibit adverse differential treatment on protected grounds. Some of those are legalese kind of wording, but one of the things that came out, and I've gone to Norm's presentation actually, and I've been at a couple others, and I think at this point, part of the human rights thing, and what's come out for me in a couple of the presentations is this zero tolerance thing. And human rights takes a very dim sort of look when they get a case presented in front of them, and they've got an employer that says, well, our policy is zero tolerance. As much as to us it sounds like that's a great thing, to human rights it's not. and to that commission, they tend to really start looking hard line at that zero tolerance. So what they're saying, everything has a degree of where it needs to be investigated, needs to be put in the right place, but zero to just say all of a sudden that arbitrarily we're just going to say everything is zero tolerance, no matter what, no matter how much, you're done, you're fired. And they will take a very hard line look at that. An alcohol and drug policy may discriminate on addiction or perceived addiction, and that's something, again, that you need to really take a hard look at as far as when you put your alcohol and drug policy in place. And a fitness for duty policy may discriminate without intention or bad faith to do so. Okay? And again, the big sort of buzzword is the fit, or the buzz phrase really is the fit for duty part of this. The employer must show that a disability which is protected under the legislation, adverse treatment with regard to employment or term of that employment, and the disability was a factor in the adverse treatment. So it still plays out the huge sort of legal aspects, right, of making sure that all your I's are dotted and your T's are crossed. So it's a good idea to make sure that, and you can't go into this process through, the fit for duty in a haphazard sort of, okay, we just have, HR people and they're going to put a thing in place. It's really strongly recommended that you take a real hard and fast and hardline look at how you're going to process that, because it's not just something you want to just throw a paper at and say, okay, we're good, right? Chief officer, operating officer signs it, and yeah, we're off and we're good. So the employer must prove it adopted the standard for a purpose of rationally connected to the job performance. It adopted the standard as an honest and good faith belief that it is necessary for legitimate work-related purpose. The standard is reasonably necessary for that work-related purpose, and it's known as Moyran test. So they're just saying, here's the things that test that process, right? So that you adopt your standard, it's for the purpose of rationally conducting your business. So however that plays out safety-wise, and I talked to this presentation pretty well from the aspect of a safety guy, right? I don't look at it from the HR side. I don't look at it from like the lawyer's view of it. I look at it from my people coming to work and going home at the end of the day with all the parts that came with, right, and upright. So that's a good thing. So this is where my presentation or my slant on this comes from. The KVP and the Moyran both deal with reasonableness. Either could be the basis for a legal challenge, the implementation of an alcohol and drug testing policy. So again, it's not just something you throw a paper at and you say, yeah, we're good, we've met the legislation, we met the requirement. If you look at your fit for duty, you have to really ensure that it is well covered. Satisfying one can just satisfy the other to justify implementation of a policy. And human rights issues also arise as a distinct issue in disciplinary or other responses to failed tests. So again, depending on where that test goes, how you discipline from that point can be challenged by a human rights issue through whether it's through a union, through an employee on their own. Supreme Court of Canada endorsed 3 types of testing through the Irving Pulp and Paper Limited and CEP and Local 30 back in 2013. And the case involved unionized and dangerous workplace and employees in a safety-sensitive position. So I'm sure that all of us on the call have, and if you look at your jobs, we all have safety-sensitive. I mean, if you look at somebody that drives a transit mixer, ready-mix truck, it's a safety-sensitive job, right? So we need to look at those. What is a dangerous workplace? A dangerous workplace includes an enterprise whose normal operations pose substantial risk to the safety of employees and the public. So again, if you take concrete mixer going down the 400, the 401 here in Ontario, it plays out, right? Certain industries are recognized as inherently safety sensitive without needing to show a history of substance abuse. So those kind of present themselves. I've made mention to Alan earlier today, if you look at, for my experience, if you look at mining, it has the safety sensitive built into it because guys are handling explosives, right? So it's huge. They're drilling, they're blasting. There's things that happen within that process. Case-by-case determination, objective testing, looking at all facts of the position. So duties, you need to lay out the duties very clearly, the responsibilities, the tools and the equipment that are going to be in that process, and the materials handled through that process. And then asking, would impairment risk the safety of employees or persons generally, or the safety of property and equipment? So you see it sort of building to that policy and that program, right? So that you ensure that and you got to be asking these questions as you go through that that process. The impairment part of it, is it going to present a risk? So under the Irving Pulp and Paper, reasonable cause, so reasonable grounds. So again, you need to be able to prove those reasonable grounds for the action that you take to believe the employee is impaired while on duty. Post-incident, directly involved in a workplace accident or significant incident. So many companies even now have taken to, for example, the two bigger mining companies in Sudbury, if I can use them as an example, they have a post-incident policy. So if something should happen, if you have a motor vehicle accident, for example, on one of their properties, it is an automatic post-incident. So then your employee, we had an employee underground, wasn't even involved in the incident. One of their employees went a little bit off the rail and struck one of our pieces of equipment. Our guy got sent for post-incident regardless. And, you know, it kind of opens up a whole sort of Pandora's box from that point, right? And return to work testing, conditions imposed following treatment for substance abuse. So if you send an employee, it's determined that they have issues, they have possibly an abuse problem with the substance, and they're going to return to work, then you have to have conditions on that person coming back and performing possibly the same job they were doing before, so that everything's going to be in the right place. Testing for reasonable cause applies where there is reasonable grounds to believe that the employee is impaired while on duty. So I mean that, you know, to try to list a whole bunch of examples, but I'm sure if we sitting in our various locations, if we think about it, we have different ideas and different reasons why we would say we have reasonable grounds to talk to someone or have someone tested. So reasonable grounds from conduct, demeanor, or actions of employees. So I mean, obviously, if somebody's at work and they're agitated, and there's things that you can determine from that, it's going to lend to possibly bringing you to that point. Odor of alcohol or drugs. Alcohol, obviously, being sort of the one that jumps out a little bit clearer. Slurred speech, bloodshot eyes, flushed face, lack of coordination, and seen consuming drugs or alcohol, I mean, all led to reasonable cause, so they would give you those reasonable grounds to say, you know what, we want to test, right? So it doesn't take, it's not sort of big at that point. Testing may be imposed where there's a significant accident or near miss, and there is no explanation except the employee's act or omission to do what needs to be done as part of their function, right? So for whatever reason, at that point, you can look at the possibility of impairment through whatever. For a near miss, the approximate proximity of harm must be realistic and the potential harm significant. So when you look at, I don't call them, in my safety career, I don't call them near misses, I call them near hits. Nobody drives down the road and nearly misses a moose, they nearly hit it. So it relates to the same thing with safety. They're not near misses, they're near hits. That flavor needs to change at some point. But, you know, again, when you look at that process, how near was it, right? Where did it move to? And we need to look at addressing that. So for significant accident, the accident must be some substance or materially or have significant consequences. So again, it plays out to, there's ample examples of that, but to try to sit here this morning and give you a whole bunch of them is just not gonna work. The employer must conduct a reasonable investigation, so guided by a non-exhaustive list of factors. So as you move through this, and I've seen Norm do it, you know, you need to start building that list, right? Because it's not going to be, it's not as simple as the guy broke a rule, we'll give him a warning slip and he goes home. It really opens up a whole other, you know, you got to make sure that everything, again, as I was mentioning to Alan this morning, dot the I's, cross the T's. So you need to make sure. There must be a connection with the employee's area of responsibility in the accident. It is necessary to investigate. So the key word here to me is investigate. You know, I'm sure everybody has their investigative process within their companies, but for this one, you need to make sure that you create a really, really comprehensive investigation checklist that puts you in the right place. Because again, you know, sort of as the beginning of the present, you may have to defend this, right? You may have to defend that process within the human rights. So if you do that, then if you have that list and it's comprehensive and it's done properly, then we can pretty well, you know, rest assured at least that we can defend it, right? it is necessary to investigate whether the actions or omissions of the employee contributed to or caused the accident. So the omissions being, they could have been by just not doing what needed to be done because of the issue around the substance abuse or the impairment. The test must assist in the investigation at a minimum by negating impairment as a possible cause or contributing factor. So again, it's going to play to both sides of that. It's either going to eliminate that whole, okay, that's another issue now, we can move away from that, or it's going to put you in a place where now your investigation is leading to that testing being a contributing factor, and you move on to it from that, you tackle it sort of from that perspective. The employer must conduct a reasonable investigation guided by non-exhaustive lists of factors. Again, the incident must be significant. The investigation must incorporate the employee's explanation of the incident. And so, everybody has the opinion, or everybody has the right to express their explanation, right? So again, it all plays out to that investigative process. And the decision to test must be based on the connection between the incident and the employee to be tested. So there definitely has to be a 100% linkage between that employee and the incident that you're investigating before you say, okay, we're going to have you tested. The employer must also balance the employee's privacy interests and the employer's interest in conducting the testing. So, and that pretty well plays out to me that it's just common sense. You wouldn't be telling anybody that this process is happening and it's so-and-so that we're testing and this is what happened. And most times, and I've said this about posting accidents and incidents on the workplace, depending on where you are, most places within the grapevine works pretty well, and phones work pretty well, and texting works pretty well. So if something happens in the workplace, you can be sure most people know anyway. It's out there, right? So from the employer's perspective, you want as much as possible make sure you protect that employee's privacy through whatever process, keep it off into a room. And of course, the employer's interest in conducting the testing. Ideally, these privacy issues should be explicitly referred to in your alcohol and drug testing policy. What are you going to do to ensure the privacy of the employee is met, right? And again, so when you're creating this policy, it's far-reaching. The policy just extends way out beyond just we're going to test. It lends out to an entire, it becomes more from policy to me to program, right? So to me, it really, really expands from just being a drug testing policy to an alcohol and drug testing program, and the program that unfolds from that as far as discipline, as far as privacy, as far as all these other elements play out to. So I think that's kind of where we need to be going. An employee return to work in a safety-sensitive position can be subjected to unannounced periodic testing. So that again is something that's going to come out of your program. So-and-so has gone for rehab for the 28 days or whatever, the initial sort of rehab process, and they come back to work. They have to be at least aware that over the course of time, that, I'm going to use that word maybe incorrectly right now, but the random testing will become an issue. That at any point, they can be brought in and asked to give a test. If there's reasonable cause to believe that their addiction or use of drug has had or could have an impact on the workplace, and this testing should be ideally be developed in consultation with the union. So if you have that labor element in your workplace and you have a union, then you really should be sitting with them, and the testing should be ideally developed with them. I mean, most of your trade unions and your unions have people that deal with either the safety or the compensation or the processes that lay out that way, and they're usually more than willing to sit down and try to iron something out that works for everybody. Just arbitrarily handing something out that way is just basically not gonna, there's no good gonna come from that. So you need to make sure that you try to do it cooperatively. Other types of testing were not specifically sanctioned in the Irving decision was pre-employment, pre-site, and random. Alan and I were having a little discussion pre-startup here about the random and proactive, and as much as that could be, it's still, from where I've sat in different sessions and meetings, and random testing is not something that I see happening in the very near future. It's huge. Most of your trade unions don't buy into the random testing, and it does lend out to sort of that whole privacy thing, right? So pre-employment, there's lots of companies that do it. Pre-site, we do work for various companies and we have to have a pre-site access alcohol and drug test before we can go there. So I think those are things, they may not have been specifically mentioned, but those are things that's the movement that I see happening through this process. Testing before employment does not establish the ability to perform the essential job functions. So, you know, that said, I mean, that's a difficult one. I mean, you do the testing pre-employment for a reason, but it may not, again, establish that number that you're looking for. And again, it's just challengeable, right? If you deny somebody just because they had a little party 3 days ago, and happen to be, and there's been situations where people have been at a party, not necessarily smoked marijuana themselves, but been in that environment and have tested. So it lends to huge issues, right? It cannot generally be defended under Moraine as a bona fide occupational requirement that has been upheld in limited circumstances. So example, drivers subject to testing under the U.S. Department of Transportation. So there's an issue around that. If you have trucks that are going across the border, they have a very stringent sort of policy on that side. So some of it plays out to that. So more likely defensible where testing occurs after a conditional offer or employment. So again, conditional offer, there's a whole sort of thing that plays out to when you do the offer, right? So positive tests, and your HR people would probably know far better than I do on that particular topic, but there is a fine line around when you make that offer and when you do the testing, okay? A positive test result does not result in an automatic withdrawal of the offer. So again, that one, just from my perspective, I would be looking at my HR people for some kind of clarity around exactly how that plays out. And there's industry evidence of drug or alcohol related issues. So pre-employment testing, again, there's 3 bullets there that talk about how you look at how you do that. And again, that issue came up around the conditional offer of employment and when that's made. So not to beat up on that, but make sure you're very clear on it. There's a recent history of drug or alcohol related issues or incidents within the company. So this is talking about pre-employment. The safety sensitive position is truly safety critical and they work under limited supervision. That would lend to that pre-employment being defensible, right? And there are no less invasive means to address drug or alcohol related issues. So again, it's going to play out very big in industry. Testing as a precondition for access to a work site, subset or a hybrid of pre-employment and random testing, and subject to similar restrictions. So it's kind of, like I say, we've gone to a few of our locations, we've had to do pre-site, and so it still sort of plays, if you look at it, it's a fine line again around pre-employment, pre-testing, or pre-site access, right? So again, it is, I think, moving forward, that's going to be a lot more prevalent in a lot of, from the contractor perspective, it's going to become huge. I think it's going to be just something that we have to come to grips with. And if you look at it from, one way is we didn't do pre-employment, or if your company doesn't do pre-employment, yet you go as a subcontractor or a contractor to a company and they do pre-site, it kind of plays out to kind of lends to your side of things as well, right? Random testing is the most difficult to justify. It's really hard to say that we're going to necessarily pick on somebody, or again, we go back to somebody that comes to work after a rehab program. That's a whole different issue. Those people that come back, you can very randomly just say, we're testing you, right? Describing the Supreme Court as unjustified affront to the dignity and privacy of employees. So really, if you look at, you may have employees that are partaking on the weekend, and you may have employees that don't. They don't take aspirin. Now all of a sudden, those people are asked to randomly give, a sample and do a drug test. It can be an absolute affront on their privacy and their, you know, I'm a clean living guy, and you're really starting to, you know, wear on me with this random testing, right? So may in specific circumstances be justified as a proportionate response to a legitimate balancing of interests. So again, depending on circumstance, depending on how severe, depending on issues within that workplace, the random or proactive testing may be something that some companies want to advance. So if you're looking at random testing, this would likely require the thought dangerous workplace. So, and I can't think of, I think we may have taken, or one of the other presentations that I sat in on, they gave sort of examples of dangerous workplace, but it was just, things were not good. Anyways, evidence of substance abuse in the workplace, for example, you know, visits by the Ministry of Labor, complaints to the Ministry of Labor, somebody's, you know, the people at the workplace are, you know, around the corner all toking up at lunchtime and that kind of thing, right? Evidence of enhanced specific extraordinary risk. So depending on, again, the work that's being done, if there is issues around, I worked in Saskatchewan on a headframe project for Potash Corp, and we had people on high steel, and we found people on high steel smoking up. So to me, that becomes super sensitive to that. You know, it's extraordinary. They're you know, 200 feet in the air on a little cable, and you know, the other thing, we got them talking on cell phones up that high in the air too. So cell phones are another issue. But you know, those are what we call those extraordinary risks, right? And those of you that are sitting around on the call, if you have those in your workplace, you know what they are. So again, there's something that you need to identify as part of your program. You need to make sure that they're in there. And the expected safety gains must be real and more than minimal. So if you take the last two bullets and put them together, it presents that sort of argument, right? It's extraordinary, it's super sensitive, it's super safety sensitive. You need to make sure that the gain you're going to get from the testing is justified, right? That people are going to go home at the end of the day with all the parts they came with. Elements of a fitness for duty policy. So application of the policy. So the application of the policy, I think, fairly across the board is sort of the issue there. You need to ensure that you have the responsibility of your workers, that they understand their responsibilities as far as that program. The workplace standards that you have really address the fitness for duty. The detection and deterrence. So what is the detection process for your fitness for duty, and what is the deterrent given the other side? What are you willing to accommodate? That's the other, you know, there's an issue around accommodation. So, and that hasn't, but you have someone that has an issue. Person has a drug dependency, has an alcohol dependency. So from, I think, the human rights perspective, you know, there's a duty to accommodate, right? And there are some legal parameters around duty to accommodate within the human rights structure. So you have to look at this person, yes, has a problem. This person's gone. They've gone for help. They've done the things that you've asked. So now you have to look at that accommodation piece. And then when you're delving out discipline, the issue is that discipline has to be consistent and it has to be fair. So you can't discipline one person a certain way and then the same thing happens to somebody for whatever reason. They're the rising star and they're disciplined differently. That sends a really bad message across the board to the workplace that, you know, it all depends on who you are, kind of thing. So your policy has to be very, very fair across the board for the discipline side of things. So 7 steps to develop and implement a fitness for duty policy, mandate from the CEO and the leadership. So if it's not driven from the top down, it's not happening, right? So we all, you know, from our health and safety policies, we have them signed by our president or chief operating officer or COO, whatever we have. This is no different. So we need a mandate. And really, if you need that, it's not simply a policy. You need something from them to say that they agree with what process is being acceptable or accepted within your company now. Management and work collaboration. So I think as we go through this process, if you're putting this program in place, you seek the whatever, you know, assistance, whether it's through a legal or an HR process, but you need to make sure that your workers, if you're unionized, it's going to happen because of just the flavor of that relationship. But if you're not unionized, then you need to keep your workers apprised of what's happening, right? Keep them informed that this is what's going on. And you know, the best sale of that is for everybody. I mean, really, we want everybody. Again, I use that term a lot, but everybody goes home with all the parts it came with, right? Occupational health, safety, professional engagement, CRSP. So if you have a CRSP, then by all means, use your CRSP, get their opinion. We have, speaking from the CRSP, we have, you know, lots of information available to us through all kinds of avenues. So don't be afraid to call on them. Expert legal advisor and legal review. That totally is recommended. And I'm not, you know, the legal people are the people that are putting these things together. They're the people that they're looking at the legal aspect of this entire process. So I think they're, you know, even if you only touch base with them and you've created it, just get an overview of it. Let them have a look at it and maybe help you dot some of those I's and cross some of those T's to ensure that it's not going to have those holes, right? Joint Health and Safety Committee review, comments, and input. So again, you know, if you don't include your Joint Health and Safety Committee, as we're all aware, at the end of the day, they come back and it just becomes, there's no good going to come from that. Involve them, put them in the process, ask for their input. They're the guys that are going to go back and sell it. If it's an issue of bringing that program into play and that policy, then really your Joint Health and Safety Committee from the labor side is the guys that are going to go back to the union hall or wherever and sell it to the employees, right? They're the guys that are going to say that this is happening for a good reason. If you don't involve them, they go back and it's not a good reason, okay? Broad training and implementation strategy. So once you've put this, you developed a fitness for duty policy, then you need to communicate it. You need to put it out there. You need to ensure, however you do that, whether it's through this type of thing, webinars or physical, you know, tailgate talks, however you do this, but you need to make sure that there's training on it and people understand what's happening. Enforce consistently, including the discipline, and we touched on that a little while ago. So if you're going to enforce it consistently. Make sure that everybody's getting the same chances as the next guy.
It's great, John. Thank you. We do have a few questions. The first question is, what is a typical time frame to implement a fit for duty policy?
Well, for more, I guess I can only speak for myself. But I mean, the legalization is October, I guess. So my window is by end of year is to have this entire package program put in play. So I would say within the next 6 months. You know, I mean, it all depends on resources. It depends on availability of people to lend to the process. So I guess really the answer to that as soon as possible, because it's not going away. It's not something that we can't. And fit for duty has been a topic that it sort of sat back here for a while, and then the legalization of marijuana and medical marijuana has just pushed it hugely in our face and said we need no fit for duty.
Okay. And just a follow-up question to that question, how much leeway time do employees typically need for a new policy?
That one is, again, just everybody has their own. Like for us, it would be to the end, you know, to incorporate this entire process. The lead time will be, my next Joint Health and Safety Committee meeting is August, so it'll move from there.
Okay. What can companies do currently to get ready for October?
Just sit with their committee, sit with their, if they're going to use, if they have HR people, bring in your CRSP or your safety person, bring in your Joint Health and Safety Committee and sit together and just start, you know, here's the things we need to do. I mean, there's all kinds of resources online that you can start this process, and some of the questions, the leading questions are there. So you can just start building from that.
Okay. And what can employees currently do? So let's say you are using marijuana currently. How can you prepare for October, for example?
That's a good one. And I don't, to talk about an employee being prepared for it, I guess, are we just talking, if we're talking just general use, then you want to make sure that you're not, you know, prior to, or you're giving that window, because as we discussed it, you know,
yeah, I guess if you're continuously using it on weekends and, you know, now you may get tested, what is something you can do to kind of get ready for the legislation?
The only thing I can say to that is back off on that. If you're, you know, like we discussed, if you're a heavy user, your testing window is huge. It's not a couple of days, it's not a couple of hours. If you're a heavy marijuana user, your testing is up to 3 weeks. So you know what I mean? I don't know how you prepare for that, right?
One question got to, does CBD oil count as a substance, and does it require the employee to disclose that info to the employer?
Good question, but I don't have an answer on that one. Okay. I would suggest they, you know, find another avenue. I'm not sure.
Okay. The last question is, will it be able to get a copy of the presentation? Yes, we're going to send a copy of the presentation to everybody that attended today, and the actual webinar will be posted, like we said earlier, on the Concord, Ontario website, so you can go back over this presentation, the recording, I mean. That's pretty much all the questions today. Again, thank you very much, John. That was great to give us an overview. If you do have any questions for John, please reach out to us. Like I said earlier, Norm Keith is also a great resource for this topic. And get in touch with Norm, have him come in and do a presentation or a policy for you. You can definitely do that. In terms of our upcoming webinars, our next webinar is August 22nd. It's the MTO Greenhouse Gas Initiative that was recently implemented. In September, we're going to be looking at structural shotcrete applications, which is another great and interesting topic. In October 23rd, we're going to have the MTO come in and do a specification updates webinar from their perspective, what's changing and what are some of the expectations for the ready mix industry. November 14th, we're looking at ground glass. It's recently been approved as a new supplementary cementing material in the new CSA. So we're going to have somebody come in and talk about that. And then seasonal loads is a big issue for a lot of ready mix suppliers. So in December, that's the perfect time to address that. So please tune in for that one as well. That's pretty much it from our side. Thank you very much again for tuning in, and hopefully everybody will join us in August. Thank you and have a great day.